Did you know that in a medical malpractice case here in New York, when we hire a medical expert who plans on coming in to testify, did you know that we actually have to notify our opponent that we've hired a medical expert and then tell them certain information about that expert? Did you know that? You want to know why? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. Your doctor denies all of your allegations. All right, so now your case goes all the way towards trial. Before trial, we have an obligation that once we hire a medical expert who is planning on testifying, I have to notify my opponent that I have hired a medical expert to come in and testify. Likewise, the defense has to do the same exact thing. Now, it's not simply a matter of me calling up my opponent, hey, John, just want to let you know I have a medical expert who's coming in to testify. Have a nice day. No, that's not how it works. Instead, there's certain things I'm required to tell my opponent to give them notice of what it is that my expert is going to say. And how is it that this person is actually qualified to say those things? Some of the things that I have to tell my opponent include my expert's credentials. Where did he go to medical school? Where did he do his internship and residency, his training? What state is he licensed in? What hospitals is he affiliated with? Has he published anything in the medical literature? The one thing I do not and will not disclose is my expert's name. How do you like that? And you might be wondering, I don't understand. We are required to notify our opponent we've hired an expert in this field of medicine. We have to tell him the expert's credentials, and then we have to tell him all about what the expert's going to say. But the one thing in New York that we do not tell him is the name, our expert's name. Likewise, when the defense lets us know that they've hired a medical expert to come in and testify for the defense, they do the same exact thing. But now here's the crazy thing. We take the doctor's credentials that the defense gives us when they tell us they have an expert, and now we plug it into a computer program. And within a few minutes, we can get the name of exactly who this person is. And the defense does the same exact thing when we tell them that we have hired a medical expert to testify. It's kind of ironic, isn't it? Although we don't disclose the name of the expert, each side does their own independent research to come up with the expert's name. Why? So that each side can do their own research, dig up any dirt on this expert, any prior testimony, get those transcripts, and now in preparation for cross-examination at the time of trial. So now let me go back to the question I raised at the beginning of this video. Why is it that we are required to notify our opponent that we have hired a medical expert? It has to do with giving them notice of what witnesses we are calling at trial. You see, if we were to bring up an expert and we didn't tell anybody about it, and now the judge says at trial, Mr. Oginski, call your next witness. Your Honor, I called Dr. Jones. He's an expert orthopedist who's going to be testifying on our behalf. The defense attorney would jump up out of his seat and yell out, Judge, objection. Mr. Oginski didn't tell us he was bringing in another expert. He didn't tell us he was bringing in this doctor. And now we are at a significant disadvantage because we have not been able to prepare. We haven't been able to dig up any research to see if we can discredit this witness. And now we're significantly disadvantaged. And you know what? The judge would be right to agree with my opponent in that instance. He would not have had an opportunity to prepare. Same thing for the defense. If they try and ambush another witness on us that they didn't tell us about and didn't give us advance warning about, we are at a significant disadvantage. I have not been able to do research on this particular witness. I don't know what this witness is going to say. This is the first I hear of it. And yes, every attorney can try and think on their feet at the time of trial, but that's not what you want to happen. You want to know going into trial exactly who's testifying. You want to know what the expert is going to say. You want to know if there's any literature that we can use to now cross-examine this doctor to discredit him. Is there something in this expert's background or history that might discredit him as well? So we don't have that opportunity. So the reason why the courts make us exchange that information before trial is to give each side an opportunity to do their own research and prepare for cross-examination. So why do I share this great information with you? I share it with you because nobody talks about this. And you know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you still have questions and your matter happened here in New York and you have not yet started a lawsuit, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.